Good morning. Good morning and welcome. My name is Marie-Claude Jean-Baptiste, and I'm the Director of the Human Rights and Access to Justice program at the Vance Center for International Justice. I also lead the Vance Center's Business and Human Rights Initiative. The initiative seeks to promote business and human rights principles, namely that both business and states have a responsibility, one, to ensure that their activities do not infringe upon the human rights of others, and two, if a violation does occur, to take steps to remedy them. As part of this work, we provide pro bono legal support to organizations all over the globe that are tackling these business and human rights challenges. We also encourage discussion and learning among the legal community on business and human rights. Our event this morning on the timely issue of whether arbitration is effective in resolving business and human rights disputes is one such discussion that I hope you will find not only interesting but also educative. It is my pleasure to introduce now Donovan, who will deliver the opening remarks. Donovan is a partner at the law firm of Debevoise and Plimpton, and he co-chairs the firm's International Dispute Resolution and Public International Law Groups. He serves as counsel in international disputes before international courts, international arbitration tribunals, and courts in the United States. Mr. Donovan served as the presiding arbitrator in the Bangladesh court case, which you will hear more about later. There is a more detailed bio of all the speakers in your handout, and also more information on the Vance Center Business and Human Rights Initiative. Donald, please.
Good morning. I'm grateful to Marie-Claude and the Vance Center for inviting me to deliver these opening remarks this morning. I'm an international lawyer. A major part of my practice has been devoted to human rights litigation, including in the U.S. courts and at the ICJ in The Hague. I've also long devoted a substantial part of my practice to international arbitration, which I believe has developed in its own right into a transnational justice system. So I'm especially grateful for the chance to discuss the intersection of these two. Okay, can you hear? Oh, really? Okay. I will tell you, people very rarely complain that I'm speaking too softly. Too loud, rather. So again, thank you to Marie-Claude and the Vance Center. The emergence of what is termed the business and human rights field, broadly speaking, the application of human rights norms to businesses and business activity, represents an important development in international law, often said to have crystallized in 2011 with the endorsement by the United Nations Human Rights Council of the guiding principles on business and human rights. This development is part of the broader progress of the rule of law in the 20th and 21st centuries. Perhaps the most important aspect of that development is the dramatic expansion of the subject of international law beyond states and international organizations. Human rights law and international investment law are the two, in my view, principal manifestations of that phenomenon. These two regimes catapult individuals and corporations into the international plane, empowering them to bring claims directly against states. More recently, we're also witnessing the expansion of the scope of international responsibility by the imposition of international law obligations on non-state actors. It's not just that individuals and corporations can bring international law claims on the international plane. They can also be at the receiving end of these same claims. You see this, of course, with the development of international criminal law. And in the civil sphere, human rights litigation against individuals and corporations in national legal systems, and in recent attempts to bring international law counterclaims against corporate investors in investor-state arbitrations. Thus, business and human rights disputes raise an intriguing possibility. An international law dispute involving not just one non-state actor, but two, with an individual corporation bringing a claim against a corporate defendant subject to human rights obligations. It's this prospect, and specifically the possibility of arbitrating these business and human rights disputes, that we have convened to discuss this morning. The third pillar, as this group will well know, of the guiding principles is concerned with access to remedy. It addresses various mechanisms to ensure access to effective remedies for those affected by human rights abuses. Any assessment of arbitration as one such mechanism must start with the recognition that human rights law faces what has been termed an enforcement deficit. To put it another way, international human rights law, like international law generally, is not at risk of over-enforcement in the current international legal regime. So we should be looking hard at any new enforcement mechanism with potential, including international arbitration. There have been important developments in this new field. What has been described as the first ever business and human rights arbitration, the Bangladesh Accords arbitration, concluded last year. As I presided over that tribunal, and as agreed with Marie-Claude, I will say no more about that dispute. Another important development is the development of arbitration rules specific to business and human rights arbitration. In June, the drafting committee of the Hague Rules on Business and Human Rights Arbitration, which is chaired by Bruno Sima, released draft rules for global public discussion, which will be part of this morning's discussion as well. For my part, I want this morning to go back to basics by mapping out how two basic arbitration concepts that would apply in business and human rights arbitration might play out. And those two concepts are consent and applicable law. I'm not going to try to reinvent the wheel. The point of my remarks is to discuss how these fundamental notions might apply in this new setting. So I'm going to start with consent and inevitably the related notion of waiver. It's trite and standard to say that arbitration is based on consent, that consent is the cornerstone of arbitration. So how would consent in a business and human rights context be given? The draft Hague Rules expressly leave out the issue. As the introductory note states, like the UNCITRAL rules, the Hague Rules do not address the modalities by which the parties to the arbitration may consent to it, nor the content of that consent, which are matters for the parties. That's as it should be. In general, it is not for arbitration rules to specify how consent may be delivered. Consider the example of the ICSID Convention and arbitration rules. The drafters of that convention contemplated that consent would be sourced in agreements to arbitrate in investment contracts and perhaps offers to arbitrate in investment laws. Now, of course, after the revolution that started with SPP v. Egypt, the first case brought on the basis of an investment law, and AAPL v. Sri Lanka, the first on the basis of an investment treaty, the principal source of state consent to ICSID arbitration is found in investment treaties, unilateral offers to arbitrate accepted by the investor upon commencement of the arbitration. When thinking about the parallel issue of consent in business and human rights arbitration, I'd propose to raise three questions. First, whether consent is given ex ante or ex post in a compromis or submission agreement. Second, whether consent is given simultaneously or at two different points in time. And third, whether the parties to the underlying agreement will be the parties to the arbitration, or whether there are mechanisms for third parties to the agreement to become parties to that proceeding. So first, the question of ex post versus ex ante. This issue arises in all arbitration. Was consent to arbitrate obtained before the dispute arose or after? We think in terms of the following trade-off. On the one hand, you can better tailor the agreement to arbitrate to the circumstances of the dispute if you know what the dispute is about. For a simple example, the optimal number of arbitrators may depend on the size, nature, and complexity of the dispute. On the other hand, once a dispute arises, it is sometimes difficult to agree on a dispute resolution mechanism, because at that point, the parties may well see their interests diverging on that point. Still, ex post agreements through a compromis or submission agreement do occur. Claims commissions, a very important feature of the history of international arbitration, whose continuing utility is demonstrated by the still active Iran-United States Claims Tribunal, constitute, of course, ex post agreements to arbitrate. The same trade-off would be applicable to business and human rights arbitrations. On the one hand, it's only after such a dispute would have arisen that numerous key features of the dispute would be known, especially the identity of the parties, of course. On the other hand, assuming an alleged victim versus business context, it would be uncertain whether the relevant business would be willing to go to arbitration once it had been accused of human rights violations, with potentially significant monetary and reputational interests at stake. We shouldn't exclude that possibility, though. It may be in a company's interest in specific circumstances to resolve allegations of human rights violations in a centralized form to be adjudicated by impartial arbitrators rather than the tribunal of public opinion or social media, and according to clearly defined legal rules and evidentiary processes. In case of allegations involving numerous alleged victims, one may contemplate various kinds of mechanisms. A mechanism to aggregate claims, consent to one large multi-party arbitration, or the creation of a sort of claims commission, establishing semi-permanent arbitral structure to receive numerous distinct claims arising out of the same original incident or complex of common facts. The second issue in my typology of consent is whether consent is given simultaneously or at different points in time. The second option is commonly exemplified, as we've discussed already, investor-state arbitrations based on investment laws or investment treaties. In that context, at the time the original offer to arbitrate is made, there is no contractual relationship between the state and the putative claimant. The state makes an open offer without knowing precisely who will be able to accept it later. In fact, in the traditional understanding, the open offer to arbitrate is part of a package to attract potential investors who know that they can have recourse to arbitration if needed, and thus, by investing, become potential future counterparties. In the business and human rights context, this open offer option must be carefully considered. There are, of course, business-to-business human rights disputes where the parties know each other and contract ex ante. For example, two members of a supply train who may wish to impose on each other certain contractually defined human rights obligations. But in most situations, in the alleged victim versus business context, the parties will have no defined relationship ex ante. If consent is given before the dispute emerges, then it means that the business will have to give an open offer type of consent. We'll have to give a unilateral offer to arbitrate to an undefined future class of potential. It may well be that businesses would be reluctant to extend an offer to arbitrate for some sort of class or mass arbitration to an undefined and numerically indeterminate class of plaintiffs. If we want to increase the probability that businesses will be willing to sign on to that type of mechanism, we have to develop criteria that might decrease the level of uncertainty by carefully defining the scope and terms of the offer. Think of the analogous situation in investment treaty arbitration, and particularly in the context of the critique of investment arbitration that has now been underway for some years. A very significant number of investor-state treaty cases are dismissed on jurisdictional grounds. States can rely on numerous limitations applying to their consent to arbitrate. A qualifying investor must have a qualifying investment. The investment must be in the territory of the host state. It must be made in accordance with the law of the host state, and the like. In the new generation of investment treaties, many states have sought to further qualify their open offer to arbitrate. For example, by tightening the definition of a qualifying investor. So it would be important in contemplating a business and human rights arbitration regime to consider what the limitations in the business and human rights context, analogous to those of investor, territory, legality, and the like, might be. It may well be that a carefully constructed arbitral process or tribunal with carefully defined jurisdictional criteria would be seen as sufficiently trustworthy that states would impose it by legal obligation or businesses consent to it in order to eliminate, for example, the prospect of multiple fora in which they may be sued. And, perchance, because they do want to comply and be seen to comply with their obligation to provide an effective remedy for human rights violations. third question in my typology of consent is whether the parties to the underlying agreement end up as parties to the arbitration, or whether other parties get involved. It's well established that an arbitration agreement can bind non-signatories by recourse to theories of incorporation by reference, assumption, agency, veil piercing, estoppel, third-party beneficiary. The distinction between signatories and non-signatories is an important one in the business and human rights context. Again, in the alleged victim versus business context, it's common to see some sort of arrangement whereby the alleged victims would be represented by an organization, a labor union, or an NGO, for example. While the organization may be involved in the negotiations of the agreement, it may be that the individual victims eventually serve as the parties in the arbitration, perhaps in addition to the organizations themselves. Having touched consent, I should briefly touch on the concept of waiver. Classically, an agreement to arbitrate constitutes an exclusive remedial process. That is, the agreement to arbitrate entails a waiver of the right to recourse in other fora, by other mechanisms, most importantly, judicial processes. Again, this is a difficult topic in the business and human rights context. It could be argued that demanding a waiver of all other recourse is some sort of trap, forcing victims to go to arbitration in order to unduly limit their options. The counterargument, of course, is that it is not fair to get multiple bites at the apple from a respondent standpoint. If business accepts to go through a process that can lead to a significant liability and downside, and that will in fact offer a fair and effective mechanism, they may well want to know that that process will not be duplicated in other fora. So let me share two preliminary thoughts. First, if alleged victims are to waive their right to recourse in other fora, one would truly want to insist on an informed consent mechanism. They would need clearly to understand and agree that their agreement to arbitrate implied a waiver of judicial remedies. Second, there might also be a middle ground whereby alleged victims have a choice of forum, but once they make their election, it is definitive. That is, it entails a waiver, a knowing waiver of other options, a sort of fork-in-the-road mechanism, again drawing an analogy to international investment arbitration. Time's short, and I will comment, therefore, only briefly on the question of the applicable law. This issue is expressly considered in the draft Hague Rules, Rule 41, with 4 drafting options considered specifically with respect to the treatment of usages of trade and international human rights law norms. Again, I give only preliminary observations. Assuming there is consent to arbitrate and the arbitral tribunal has the authority to decide the dispute, the next essential question is what norms the tribunal may apply, whether fundamental human rights norms or individual protection cast in some other form or guise. Broadly speaking, there are 4 options. First, contractually defined norms. These are the clearest ones, typically applicable in the business versus business context, but much more difficult to use in an alleged victim versus business context when there is no original privity of contract and the alleged victims have not necessarily participated in the definition of the contractual norms. Second, norms of domestic law. The tribunal could apply human rights law to the extent that it has been incorporated and reflected in domestic law. There is a proliferation of human rights protections and statutes under domestic law, including, for example, the 2015 United Kingdom Modern Slavery Act. Third, trade usages. As just noted, the draft Hague Rules emphasize this source of norms. This would be some sort of lex mercatoria of human rights law, fascinating notion to contemplate, or perhaps the conceptual equivalent of customary international law, but in a field centered on non-state corporate entities. The concerns here are the same ones that apply to commercial lex mercatoria and to some extent to customary international law. The difficulty in identifying clear norms, the need to determine whether the norms are as then accepted or subject to progressive development, and the reliance on the discipline of the decision makers in identifying and applying these norms. Again, issues that we see all the time in other contexts. Fourth and finally, of course, international human rights law norms. This is another source rightly considered by the draft Hague Rules. While this is potentially a very rich source of norms, it raises an important, again, conceptual question. Which norms created in the context of individual-to-state disputes are meant to apply to corporates as well? Does the scope of the norm encompass non-state entities as potential subjects? And even if that's the case, is the norm meant to be actionable on a plane not involving states? In other words, what's the source of the cause of action by which the norm will be enforced? To repeat an earlier thought, we're living in a universe of imperfect and incomplete enforcement of human rights norms. And many of us have sought to open up new fora for human rights claims or to make existing fora more effective. In the business and human rights context, the prospect of arbitration as a means of dispute resolution raises fundamental questions of arbitration law. While we have hard thinking to do, I hope that these remarks will contribute to further examination of how basic international arbitration principles can be applied in the business and human rights context. I'm very grateful for your patience, and I look forward to the rest of the discussion this morning.
Thank you, Donald. We will now continue with the panel conversation, which will discuss in greater details the pros and cons of arbitration to resolve business and human rights dispute. I'm pleased to introduce our panelists. To my right, Jenny Holdcroft serves as the Assistant General Secretary of IndustriALL Global Union, which represents 50 million workers in 140 countries in the mining, energy, and manufacturing sectors. She is a member of the Steering Committee of the Accord on Fire and Building Safety in Bangladesh. Mrs. Holdcroft has extensive experience in negotiating collective agreements, training, and advocacy. IndustriALL Global Union was one of the claimants in the Bangladesh Accord arbitration. Next to Ms. Holdcroft is Robert Thompson, who is a member of the California Bar and a former Associate General Counsel of the U.S. Environmental Protection Agency, and a former partner of Leboeuf, Lamb, Green, and Macri LLP, where he was the chairman of the firm's International Environment, Health, and Safety Practice. He is currently a member of the Working Group on Business and Human Rights Arbitration Rules. In the middle, we have Meriam Al-Rashid, who is a partner and the U.S. head of the Public International Law and Investment Dispute Team at Dentons U.S. She is also a member of Dentons Litigation and Dispute Resolution Practice Group, where she focuses on public international law, including issues related to human rights, international investment disputes, and commercial arbitration. Mrs. Al-Rashid is a member of the Vance Center Committee. Next to Ms. Al-Rashid is Yousuf Aftab, who is the founder of and principal of Enodo Rights, a New York-based corporate human rights strategy boutique. He has extensive experience advising Fortune 100 companies, investors, law firms, and governments on operationalizing the UN guiding principles on business and human rights. Mr. Aftab has published and presented widely on the intersection of corporate responsibility and law, and is the co-author of Business and Human Rights as Law Towards Justiciability of Rights, Involvement, and Remedy. Last but not least, Marney is a partner at the law firm of Covington and Burling LLP and co-chairs the firm's International Arbitration and Dispute Practice Group. She serves as counsel before numerous international tribunals, advises on commercial and investment treaty cases, and litigates international law issues in U.S. courts. Mrs. Chick represented global labor unions in the first binding arbitration under Business and Human Rights Compact, the Bangladesh Accord. Thank you. I'll pass it on to Meriam now.
Thank you, Marie-Claude. And thank you, Donovan, for an excellent keynote, which I have to say is perfectly segued into everything we very much want to talk about today, and I imagine that was intentional, so great. Let's move straight into a just fundamental question, which may seem sort of daft to ask, but I think it's an important one to set the stage here. And this one is to Yousuf. You have, as we heard Marie-Claude say, extensive experience in advising multinationals on human rights concerns, and notably the implementation of the UN guiding principles on business and human rights, so which we know contemplates arbitration as one of the mechanisms for remediation. So if you could just start us off with the basic question, what is business and human rights, and how would you define it? Some simple sort of examples that constitute business and human rights disputes.
Sure, yeah. So thanks, Meriam, and thank you, Marie-Claude, and everyone for attending. So I think the easiest way to set the stage, so the idea of businesses having impacts on human rights is probably existed as long as business has existed. That's to the extent that there can be exploitation, there can be adverse effects. The idea of business and human rights as a discipline, and really as a legal discipline, is built on a simple concept to some extent, sort of a standardized definition of business respect for human rights. That term, as a defined term, that's what has grounded the emergence of a discipline of business and human rights that exists now. It's nascent, but exists in law and exists far beyond law. And that definition has three features. And so the features are, first and foremost, business has a responsibility for all human rights identified under international law. So it's not just labor rights. The second is that that responsibility is defined not by ownership or control, but by involvement. And that's a term of art, which probably not worth getting into right now. But it does go beyond the corporate veil. It does go beyond sort of business relationships and a separate corporate legal personality. And then the third, and this is the most important piece, is that the measure of respect is governance, right? So one understands whether business respects human rights based on the strength of its policies, due diligence programs, remediation efforts, and disclosure. So it tracks very closely a sort of standard compliance model that we're very familiar with from the money laundering and corruption context. And the combination of these elements, and particularly that last element, is what has created the potential for a discipline that's based on a structured, precise definition that enables accountability. So it enables accountability from objective observers, whether that's going to be regulators or courts, but it also enables accountability from investors, from civil society groups, and so forth. So that's that. When we're talking about business and human rights now, that's what we're talking about. We're talking about this discipline of structured, accountable, measurable responsibility that businesses have for human rights. Now, that definition is powerful because of the accountability factor, and if we talk about the kinds of disputes then that might constitute business and human rights disputes, there are myriad, and they are ongoing, but I'll just talk about three that I've been involved with, and there are three that have been in different fora. So the first had to do with a mining company, Barrick Gold, had operations in Papua New Guinea. There were allegations that their security forces engaged in committed heinous abuse, sexual violence against community members. And Barrick Gold set up a mechanism because the courts weren't trusted and various other gaps, they set up a mechanism that was independent to address those issues. The second is litigation that's now ongoing against Shell, having to do with environmental pollution in Nigeria. And that's litigation that's now going through the UK courts. So more standard conventional dispute resolution mechanism. And then the third is one that I'm currently involved with that has to do with a US industrial products manufacturer, and it sold equipment significant quantities of equipment, power equipment, to a foreign government. That government allegedly does not have the best labor practices. And there's I know we haven't touched on this, but OECD National Contact Point process, which is just a quasi-regulatory process under the aegis of the State Department that is proceeding, where various unions have brought a claim to urge our client to encourage that government to be better. So this is sort of, as you can see, the disputes run the gamut, and the fora run the gamut as well. And we're going to hear about further fora coming up now.
Thank you, Yousuf. This next question is for Jenny. We'll move on now to get a better understanding of just to give us the foundation really here on how that began. Your organization, IndustriALL, was responsible for negotiating this accord and actually filed the 2 claims at the Permanent Court of Arbitration on behalf of various organizations and unions against global retailers. Can you give the audience a bit more background regarding what triggered the accord, and broadly, bearing in mind confidentiality, of course, the claims at issue in the arbitration and process/procedure?
Yeah, so hello everybody. So I've actually prepared a PowerPoint because I was asked to at least give you a little bit of background, because I know there's a lot of interest in the Accord because it's one of the few examples, it's perhaps the only example so far, of international arbitration being used. And I'm not sure the familiarity that you all have with the Accord and how it came about. So we've already heard what IndustriALL is. Our members are national unions. So in this context, we have many national unions in the textile and garment industry that are affiliated to us, specifically here in Bangladesh. You would have heard of the Rana Plaza collapse in April 2013 that killed over 1,300 people. This was a huge trigger that made the brands that were sourcing clothes from Bangladesh take the whole safety issue much more seriously. In the aftermath, I should just quickly say that there were many incidences leading up to the collapse of Rana Plaza, where many workers lost their lives. So there were fires, building collapses, and on the right-hand column is the number of workers who were killed in each of those factories. So it was an ongoing issue. Clearly, none of the brands' unilateral CSR efforts were doing anything to stop people dying. So finally, with Rana Plaza, that gave sufficient impetus to sign the Bangladesh Accord. We started off with a handful of companies. Very quickly, we got more than 200, about 220 companies in the end, signed the Accord. And when I say they signed the Accord, what they actually signed was an individual contract between the single company and IndustriALL and Uniglobal Union. Uniglobal Union represents retail workers, so the people who are selling the clothes that are made in Bangladesh. So the Accord, we sort of group all of those contracts together and call it the Accord, but it is actually made up of separate contracts, which will come important in a moment. So it's quite a big operation now. We inspected 1,800 factories, set up a whole operation in Bangladesh with the money that was funded from the brands to do that, covering a couple of million workers, uncovered 100,000 safety violations, and then put each of the factories on a planned route to remediation with the aim of getting all of the discovered faults remediated to save the lives. I have to say, just in way of context, no worker has died in an Accord-covered factory since we started doing this, so it's been incredibly effective, and the legally binding nature of those contracts played no small role in that. So we still haven't completed. It's been 6 years now, and not all of the factories by any means have completed their remediation, so it's an ongoing process. But we also did training as well, because health and safety is obviously more about more than just structural safety. There have to be knowledge and awareness and ongoing safety work in the factories. So that's briefly what the program is. I just want to show you what it looks like to train over 1 million workers. We did mass meetings in all of the factories, gave each worker information about their health and safety rights. It's very important work, which I don't want to gloss over, but in the interest of time, I'll get to the bit that we're interested in here today, which is about how did we enforce this agreement. So, from a trade union perspective, this is the first legally binding agreement at global level between multinational companies and trade unions. We have a number of agreements with companies, individual companies, in the general course of our work, but none of those are legally binding, but we hope to get to that point, and we're hoping that this will be a positive example of how to do that. We have a dispute settling procedure under the Accord, which is handled by a steering committee, which is made up of equal numbers of union representatives and brand representatives, and I'm one of those. The decision of that steering committee on the dispute can be appealed to a final binding arbitration process, which is how we got to the arbitration process. The Accord agreements, remember there's over 200 of these separate agreements signed with the global unions. They have standard language, and they say that any arbitration award under the agreement shall be enforceable in a court of law of the domicile of the signatory. And it didn't actually say that in the first Accord, but we'll go into more detail later perhaps. But it also said that the process would be governed by the IndustriALL rules. We had no process. This was the first time this had been done. So we took the IndustriALL rules as our process. We tried to negotiate with the companies something that would be more specific to our needs, but by the time the arbitrations came along, we hadn't completed that work. We still haven't actually completed it, it should be said. But what we've put as new language in the Accord when it was renewed in 2018 is at least that the arbitration shall be seated in the Permanent Court of Arbitration. So, the arbitrations themselves. We had used the dispute settling process in the Accord to talk to a large number of brands that we felt had not been fulfilling their obligations under the Accord. We spent many months doing this. Most of the companies performed better. But there were 2 companies that, despite our best efforts, we still felt were not doing enough to uphold their obligations. So we filed cases with the Permanent Court of Arbitration. The PCA found that the cases were admissible, and that decision is available on the public website. But in the end, we settled both of those cases, and I'm very glad that we did settle them, because from our perspective, the time frame of the arbitration was going to be very, very long. I should say that the time frame for mediation turned out to be much longer than we expected as well, and by now the cases would have been heard and we're still doing the remediation. But at the time we were very impatient that what we wanted out of this was to get the factories remediated. That was the whole point of it. And I think this is a very important point for the discussion today, is what does remedy look like? We were not there to get punitive damages against the companies. We were not there to get money for victims. We were there to get the factories fixed, because that was what the contract required the companies to do. The companies were required to make sure that the suppliers that were making clothes on their behalf remediated their factory. And the second obligation on the companies was to make sure that it was financially feasible for them to do so. And those were the 2 obligations that we were seeking a decision on, because we felt that these companies were not doing sufficient for the factories that supplied to them, who were not remediating quickly enough. As I said, both cases settled. We were able to reach an agreement. There are certain confidentiality arrangements around this. I can't name the brands. I can't say what the amount of the settlement was for one of the cases, but for the other case I can, and that was $2 million into a fund for remediation, plus $300,000 for IndustriALL and Uni to do supply chain work, and I'll tell you what we're spending that money on in a moment. That money is now going directly to factories to remediate. So that was what we needed from this arbitration. As I said, it was not about punitive damages. It was not about money to victims. Victims were not identified in this. It was a pure enforcement of the contract that the unions had signed with the companies. It's important to also understand in the context of labor disputes that we have an ongoing relationship with these companies because our members are working for them either directly or in their supply chains. So we don't want to have an arbitration mechanism that blows up that relationship. And it's interesting to note that both companies that we took to arbitration subsequently re-signed the accord. They were not afraid of entering into this sort of legally binding arrangement, even though they had been taken to arbitration. So we believe that there is an understanding developing among the companies that we are working with of the benefits of entering into a legally binding contract, which is, of course, what they do at national level. It's only new because it's at international level. What we did also learn from this process is there are things that we would like to improve. As I said before, it was very slow for us because we wanted to get to that remedy more quickly. We also want it to be accessible and affordable. And when your trade union's taking cases against multinational companies, that's not always obvious. And it's excellent that Marney is here because without the support of Covington and Burling, we would not have been able to take these cases. That's absolutely clear. So what we are doing as IndustriALL and Uni, we're using that $300,000 that I mentioned before from the settlement to do some work on setting up our own international arbitration mechanism for global labor disputes. So we want to create a mechanism that will do the things that we need to be able to enforce the agreements that we reach with the companies that employ or employ our members or do business with companies that employ our members and so on down the supply chain. So we've had some ideas about how to streamline the process, but our model is not so much what else is happening in international arbitration around other types of disputes. Our model is how national arbitration works in national labor disputes where you have a contract between a union and a company and you have a legally binding arbitration process to settle the disputes that arise under it. And I'm out of time, so thank you very much.
Thank you, Jenny. We'll try to hopefully address some of the other points you would have made throughout the course of the panel discussion. Let's move on now, focusing a little bit more on the Bangladesh Accord, just briefly here. This is for Jenny to contribute to. What have your experience about the similarities? My microphone keeps coming in and out, and I can tell. I do. Thank you. Starting again. Okay. So what have your experiences been when you consider the similarities and differences between the Bangladesh Accord procedure and processes, which we understand is narrow to a specific sort of industry and event and concerns and parties, versus other international arbitrations? And would you like to start first, Marney?
Sure, I'd be happy to. Thanks, Meriam. So in many ways, as Jenny's presentation highlighted, there are some unique aspects to the Bangladesh Accord arbitration that differ from other international disputes, and also my feeling is some international business and human rights disputes that are contemplated under the current draft rules, which I know we'll get to in a moment. And that is, in essence, this was a contract dispute. And so, perhaps surprising to some people, it had a lot of characteristics of a traditional commercial arbitration between contracting parties. There were obligations. They were enforceable through a clause that provided consent to arbitrate. And then those parties, the unions enforced those contractual obligations through the arbitration mechanism. It also was a quite complex dispute. It involved complex issues of causation and remedy, because multiple brands and multiple signatories to the accord were operating in each factory that had not yet been remediated. And yet each individual brand had a distinct obligation to ensure that that remediation was taking place and that it was financially feasible to do so. So in terms of similarities, this was a complex contractual dispute that raised complex substantive issues. But in terms of the differences, from my perspective, from the legal perspective, there are two differences came to mind. And I know investment treaty arbitration is often kind of brought up in this space because it is something where there's a public interest, and in business and human rights disputes there's a public interest. But unlike those disputes, where often an investor is walking away and therefore there is not an ongoing relationship, here, again, a bit similar to some commercial disputes, there was an ongoing relationship between the claimants and the respondent. The unions were still working with all the brands, including these two brands that they had brought the claims against, to ensure their ultimate objective, which was not just to get like a payout for victims of the Rana Plaza disaster, but was to actually bring garment factories in Bangladesh up to building and safety code standards to ensure the safety for Bangladeshi workers. And because there was this ongoing relationship, this was seen as we're enforcing particular obligations under this agreement, but we want to come out the other side with a solution. And in my mind, one of the reasons this case settled, as Jenny alluded to, was because the parties, with the pressure of the enforcement mechanism there, were able to realize that there might be a more efficient path forward to settling the dispute so they could move on with that relationship. And the unions currently still have a relationship with those two brands. So I do think an important lesson from the Bangladesh Accord is that there should be a way to resolve these disputes that's not scorched earth, but sees that there is this, what's the specific objective that you have in mind to accomplish, which might be payment for victims, but might be something else, especially if it's forward-looking in terms of remedy. And that ideally there'd still be an ongoing relationship with the multinationals and the workers involved in a given setting. And the last thing I would say about a distinct difference between many arbitrations and this particular one, which I think is similar to a lot of business and human rights disputes, is what I would call an information asymmetry. Because the multinational company, in this case the fashion brands, they're the ones that know what their contractual relationships look like. They're the ones that know the terms upon which they're sourcing from garment factories that are supposedly supposed to enable the factories to be able to remediate their buildings up to code. And the unions don't necessarily have access to that information. That creates some procedural complexities and a real need for document disclosure or discovery, which usually involves groans on all sides. But there has to be something in these proceedings to right that information asymmetry so that both parties have what could be referred to as equality of arms in terms of the factual basis for what's happening, and that the arbitrators are then able to see the complete factual picture. And in this context, for claimants to be able to bring a case, they really do need some kind of document disclosure from respondents to level the playing field on the information asymmetry.
Thank you. Just not my day with these, huh? Thank you, Marney. I did want that question to go to both Jenny and Marney, but in the interest of time, I'm going to do the following, bearing in mind that I know Bob here on my left will have some comments on this very sort of subject when he gets into his section. Jenny, can I ask you then to tell us and the audience we know that costs for arbitration are oftentimes an impediment, especially when it comes to what we're looking at as the future of of business and human rights, and when you're looking at more individual victims and not just the enforcement, as you quite rightly put, for the Bangladesh Accord, it was an enforcement. It wasn't victims coming forward and you had specific victims. So, but with that in mind, can you just kind of give us an idea of how we can make arbitration more accessible to victims in the future, given that we know cost to arbitration is quite expensive?
Look, it's difficult for me to answer that because we would never be taking cases against a company on behalf of victims. As trade unions, we can only act on behalf of our own members. So yes, you might identify members as victims, but what we envisage using arbitration for is to enforce agreements that we make with companies. I mean, I'm very interested in the work that's being done around this field, and I think once we see it develop, we would certainly want to use it in that way. But this has not been our experience to date. This is not something that we're expert on. What we're expert on is negotiating agreements with companies and then enforcing them. So my experience of this was only on arbitrating national level agreements, and that process, I'm from Australia, and in Australia there is a very strong emphasis on conciliation and arbitration of industrial agreements. And that process is quite open to the extent that you can go as a union official and represent your members in that process. And you may have union lawyers accompanying you or taking on some of the arguments, but it's very much fact-based because it is led by the people who are directly working with the companies involved. This process was fundamentally different to that. This process was very much that we would not have had access to it because the first arguments that we had to present had nothing to do with the facts. They were all about the process. We had to argue for which law would apply. We had to argue where the seat of law would be. We had to argue around document production. We had to argue around timeframes. This was not a process that was anything like what we had experienced at national level. So that is why we are looking at developing our own mechanism of international arbitration, because precisely we don't want to get caught up in that bind of being subjected to a very processy approach which does not have the facts of the issue central to the arbitration, which is why for us it makes most sense to start with a contract with a company where we have clearly agreed what the terms of the contract are, what the limits of the obligations are, rather than opening it up to the entire field of human rights and expectations on that company. And I recognize that that perspective is unique to trade unions, that for other groups and NGOs and victims out in the world, they won't be able to be in that type of relationship. And it comes back to the very questions that were raised at the beginning, is what is the underlying contract that is being enforced? From a labor union perspective, we're very clear what our type of underlying contract would be. So it may be that we do need to distinguish different types of business and human rights arbitration depending on who the actors are, what the nature of the issues are, rather than having a one-size-fits-all approach. And that's certainly what we are trying to develop very much for our own needs. But we still, of course, remain very interested in the broader discussion as well.
Thank you. Let's move on more to the sort of broader discussion of arbitration, business, and human rights. So I'm turning this over to Yousuf here, and bearing in mind that Bob and Yousuf may exchange a few ideas, as will Marney chime in when she'd like to. So Yousuf, how important is it, from a business vantage point, how important is it for multinationals to take into account human rights? You touched upon this briefly at the outset. In the context of corporate responsibility risks, including legal, political, and financial risks. And what's the main advice that you would provide to multinational heads in this context?
I mean, so in short, it's increasingly important. It's in my background, and the sort of the start of Enodo. Before that, I was doing mainly investor state arbitration work, commercial arbitration, and it was in that context that I started seeing the potential for these risks. And so, and that's really what inspired sort of the work we do, which is to help companies manage it. And the risks really break down into 4 different kinds of risks. So the legal risks are material and they are increasing. It is, to some extent, sector dependent. But the brand risks are huge, and they apply across sectors. The investor risk is increasingly a piece that moves companies. I'd say most of our clients come to us because of shareholder pressure. And so what you're seeing is that, and these risks are all interdependent. So there is the political risk element as well that applies in different contexts depending on the sector. So it can apply to the kind of regulation you might expect when pushing for a new product. It can apply to environmental permits and so forth, particularly in the resource sector. So companies need to be conscious of all of these. What has changed is that reputational risk piece existed for a long time. That's, there have been campaigns against companies, certainly since the 80s and 90s. But what's changed now is that the risk is not just a matter of public relations. The risk is a matter of a potential lawsuit. There's potential litigation. There's the investors are, I'm not sure if this came up earlier today, but BlackRock has made it clear that they're going to be looking for better ESG performance, environmental, social, and governance performance from their asset managers. They're going to look to them to ask more questions. So, and all of these risks are interdependent. What that means is when addressing the public relations element of it, it's critical that companies are preparing for potential litigation. It's critical that when they issue a policy, it's something that they know they can abide by, because that is now actually an actionable representation. It might be used to pierce the veil or to make those allegations and those arguments down the road. And it's certainly going to be subject to investor questions and questions from ratings agencies. And so, broadly, our advice comes down to when you are trying to address and navigate these human rights related risks to your business, make sure to do it in a way that you can explain to different stakeholders. Make sure to do it in a way that you can explain to the investor when they call, that you can explain to a court or a regulator when they're knocking. And that means make sure that it's structured. So it is based on policy, based on due diligence, and based on remediation, which is a critical piece of it, and disclosure, and all of that needs to be coherent. Can't just say we're going to save the world. You need to say exactly what you're going to do. And I think the Bangladesh Accord is a great example of sort of the specificity of expectations in this context, where it's not just make sure nothing bad happens. It's specifically take these measures to minimize the risk to workers at this number of factories, et cetera. So I think at its core, it's being ready to tell an effective story that's aligned with a systematic approach to navigating risk.
Thank you. I know, Bob, you have something to say about how important it is for multinationals to take into account human rights. Would you like to chime in there?
It's a good place to start. First of all, I want to thank Mr. Donovan for a very, very clear presentation of the issues that we have faced. And for this audience, I should say that I'm a sort of a veteran of the environmental movement. I started my career back in the 70s and ended up spending 12 years with the Environmental Protection Agency as it was trying to get its programs off the ground. Many of the issues that Mr. Donovan discussed were issues that we faced in the Environmental Protection Agency, and one of them was how to get the companies started. In the early days, there was very little attention being paid to environmental protection, partly because the states were not doing a job of enforcing, partly because the federal government was very confused in its approach. But in the 70s, a whole series of statutes were enacted, and there were severe penalties, daily penalties of $25,000 a day for violating some of those statutes. And nonetheless, getting companies to pay attention was our greatest threat to the viability of the environmental movement. And frankly, we spent a lot of time devising enforcement strategies which caught their attention. One of the things that we did was whenever there was a criminal prosecution, it was publicized throughout the United States. We made a great effort to publicize the fact that people were being actually either threatened with jail or actually sentenced to jail for violating environmental statutes. When Mr. Donovan said that there is not an excessive enforcement in the human rights area, he is absolutely right. And then one of the problems that we face is that companies don't take it seriously because the likelihood of a downside event in the life of a multinational for a human rights violation is a little bit like getting struck by lightning. But when you are struck by lightning, it gets your attention. And so one of the things that we need to do is to, for those of you in the room who are advising companies, is to be aware of the instances where people are struck by lightning, where they get sued or they get a tremendous public relations campaign against them, or some other downside event, so that you can put into perspective the company's responsibility. I think that there is a growing series of statutes that are being enacted. The Human Slavery Act in England, the comparable statute in France. There was an effort being made at the international level to adopt a new treaty which will essentially criminalize make companies subject to criminal penalties as well as civil liability if it's ultimately ratified. Efforts are being made, but they're very, very slowly being made. So at this point in time, it's very difficult for a company to understand it really must, for legal reasons, pay attention to human rights law. There are other arguments that to be made. One of them is just sort of the moral argument. I mean, the administrator of EPA, when I was there, once said, he said, you know, people have wives and children. They have to go home and tell their wives and children why they're polluting. And that I think, is a very important factor, that executives in multinational companies are human beings, and they really have to account to their colleagues and their families as to why they are using suppliers who, for instance, use slaves or traffic women or whatever. So there's the moral component, there's the public relations component, there's I'd say a slim legal component in the argument to be made for why you should pay attention. Fast forwarding a little bit, the project that I'm actually involved in two projects involving human rights in business, but the projects that we're involved with make the assumption that a company has actually made a decision to clean up its human rights situation. And what we're doing is we're creating the tools which they can use for that purpose. The first set of tools is arbitration rules, which we have a drafting team. There's a discussion in the paper that I handed out about what the drafting team is trying to do. For those of you who would like to get some perspective on modern arbitration in human rights, you might want to take a look at the paper that's noted at the bottom of the little handout. There's a paper we wrote which summarized the results of about 6 years of multilateral consultation with NGOs, with business, with academics, with government officials, the OECD, et cetera, et cetera. We carried out a lengthy consultation process to try to suss out what the issues were, and then to try to figure out what the options were for addressing those issues. And that's summarized in the paper that's noted at the bottom of the handout. And then one of the conclusions we came to is that there was a need to examine whether the existing international arbitration rules are adequate to handle human rights cases. And what we had discovered was that the perception of international arbitration, or arbitration generally, among the NGO community, among the human rights people and the human rights NGO community, was extremely negative. They were concerned about, first of all, about what they call the arbitration mafia, which is to say that arbitrators, in their view, were business lawyers who were beholden to business interests, and therefore they would probably shade their decisions in favor of business. That's a widespread perception. That led to a series of recommendations that we made to create rosters of people with expertise in arbitration within each of the international arbitration institutions, and also that there should be a code of conduct. And one of the recommendations of the draft Hague Rules is that there be a code of conduct dealing with impartiality and lack of conflict of interest and so forth. Second perception was that arbitration, particularly in the consumer area, has been abused. And this is something that Mr. Donovan picked up on. If you buy a toaster, let's say, and it electrocutes your child, just as a horrible example, you may go back and find out that the sale agreement said your only recourse was mandatory arbitration before an arbitrator chosen essentially by the toaster company. No court case could arise out of that, and this issue was dealt with extensively in the series of New York Times articles a couple of years ago, and it really poisoned the air in terms of the discussion we were trying to have about international arbitration, because it looked as if the victims were going to be told, if you have a problem, you have to do mandatory arbitration before the arbitration mafia, and so what's the point? That's another problem that we had. The third problem had to do with what we call inequality of arms. That victims are poor, companies are rich, it costs an arm and a leg to do any kind of process, particularly in court and probably similarly in international arbitration. How in the world are victims ever going to get any justice in this world? That issue is one which is probably the hardest issue to deal with, but we've done some work on that and come up with some suggestions. One is that we have to recognize that victims are not going to come in as individuals. They'll come in probably as some kind of class. They'll be represented by an international NGO or by a labor union. They would probably have, it's conceivable that they could, in some countries, they would have a contingency fee associated with the claim. In other situations, there could be what we call third-party funding, which is where an outside investor invests in essentially a tort claim and shares in the proceeds if they win. Another institution we're looking at is an international trust fund where donations are made into a trust fund which will fund the victim's expenses in one of these things. And finally, there's the issue of fee shifting within the rules, and that is addressed in the draft Hague Rules, which authorizes the arbitrators to take into account, when they allocate the costs of the arbitration, the relative burden on the different parties. And fee shifting is a very controversial issue. I will say in the environmental context, fee shifting was an extremely important aspect of the success of the environmental statutes, because what it said was that if an environmental group like the Sierra Club sued somebody and won, they would get their fees paid for by the defendant. However, if they lost, they didn't have to pay. And that's called reverse fee shifting, and it could be one way in which, if it's ever imposed by governmental authority, that could essentially overcome some inequality of arms issues. Now, the issue of consent is probably one of the hardest issues to deal with. And here's where we sort of come out on that. The companies are likely to want to resist any changes from the existing international arbitration rules. They're familiar with those rules, they trust them, and it basically gives them the kind of protections and rights, due process rights, which they want to have. If you inject into arbitration rules elements that business are not familiar with, you're going to decrease the likelihood that business is going to want to consent to the use of those rules. Now, on the other hand, business may have to make some concessions, and as Mr. Donovan has pointed out, there are situations where, despite the fact that you have to make substantial compromises in an arbitration proceeding, it may have advantages over simply a multi-year litigation process or a multi-year disastrous shootout in the internet with some NGOs and your own shareholders and investors after you to try to clean up some kind of problem. An example of that was the asbestosis litigation involving the miners in South Africa. They sued in an English court, went for years of legal pleadings. Finally, they were so tired of the expense and the adverse publicity that the companies agreed to arbitrate the process and agreed that that they would pay the fees of the victims. And that was arbitrated before some senior judges in South Africa, and they came to a very quick solution. And so there are times when companies get backed into a corner and want to get out of that corner, and that's why we have arbitration offers a tool to do that. My time is up, so I'll turn it back over.
For the moment. So now that you pointed out a few, I guess, challenges and both some ideas about why arbitration would be useful, it's obviously a very complex subject that requires a great deal of depth and hours to discuss. I'd like to just go back then to Yousuf and perhaps Marney and Jenny chime in on this. Have you, Yousuf, in particular, recommended to businesses to go ahead and use or insert arbitration clauses in their contracts, or whatever they may be, supply contracts or otherwise, encompassing business and human rights disputes in their contracts? And if so, or if not, how they reacted either way?
Thanks. So the short answer is no, and that we don't recommend it for a couple of reasons. At the moment, if you look at the guiding principles and what's expected of remedy, yes, arbitration is a possibility in certain contexts, but the truth is the preferred method to resolve disputes is through engagement, is through something that would be more like mediation. But beyond that, there are real challenges, many of which Donald touched upon when it came to arbitration in the business and human rights context. At a conceptual level, there's still a lot of uncertainty around third-party beneficiary rights. There's still a lot of uncertainty around choice of law. And there's still a lot of uncertainty in terms of what that process would, at the end of the day, what it would look like when it comes to remedy, and making sure the remedy is not just compensation, but involves specific performance elements tied into what would be considered effective remedy under international law. And so I think these are a number of challenges that persist, and there's no current trusted institution that we could possibly recommend in that context. And so it's not, while we do encourage companies to treat these expectations as enforceable under contract, arbitration as sort of a standalone approach to resolve specific human rights issues is not something we would currently encourage.
I'd like to be a little controversial here in that all an arbitration clause is an enforcement mechanism. So any company that really stands behind specific commitments, that it's a specific context, really should not have a problem agreeing to an enforcement mechanism in case a dispute arises. As Bob alluded to, actually the chill and the concern about arbitration tends to be more on the NGO side. Every multinational routinely, weekly, monthly, if not daily, is entering into contracts that have arbitration clauses, because that is how businesses prefer to resolve disputes. And particularly in a cross-border context, almost all of my corporate clients agree to arbitrate disputes so they don't get dragged into courts where they don't want to be. So I think that the real issue here is whether corporations are willing to agree to an enforcement mechanism, because the process and the procedures are something that they are quite familiar with.
I might just, and of course I completely agree with what Marney's saying on that front. I think this comes down to a distinction between the two types of dispute that Donald was talking about earlier, right? So in business-to-business dispute, if you want to enforce something against a supplier or business partner, that's fine. That can follow the conventional methods. So sort of when I think about business and human rights arbitration writ large, it is providing a venue in the kind of context that Bob's talking about for stakeholders who would be affected, who are not parties to any contract, to bring a claim to make sure that it would be enforceable against the company. And there, I think, there's tremendous uncertainty that is completely unsettled in terms of the scope of consent, what the law would be that would apply. And if we look at human rights policies that companies have, they will adopt a lot of the language now from the guiding principles on business and human rights, for instance, and say, for instance, that their commitment is to look out for and address impacts that they may cause or contribute to or to which they are directly linked. Now, these are terms of art, and yet they are terms of art that so far have rather unsettled definitions. And so to make that kind of commitment enforceable to an undefined set of claimants, I think that's where we would not encourage a company to go that far, to make that kind of commitment enforceable in front of this kind of law.
Yeah, I think we could agree that there's certainly two different types of commitments. One is a specific contractual obligations like the Bangladesh Accord, so something that's specific. The other is general, UN guiding principles where no one's really agreed to an enforcement mechanism for these very general principles, and so there's a lot of uncertainty. But I think, and Jenny may have a comment, that there's ample scope for entering into more specific agreements where arbitration can be a remedy because there's less unknown, because it can be tailored to the specific.
That's the key for companies, because you said they enter into business-to-business contracts that are binding, but they also enter into contracts with us that are binding at national level, and as Marney said, the Bangladesh Accord. We have other agreements with multinational companies. We call them global framework agreements, and they set out specifically what our expectations are of them in human rights. But it's tied very much to the ILO core labor standards and areas like health and safety. They're what you would expect for not only the direct employees of the companies, but the supply chains. These are very important agreements because they codify what our expectations of those companies are. So they're a step beyond CSR. It's companies, well-meaning companies, taking these obligations that they've put on themselves through their CSR policies and turning it into something that is more accountable by signing an agreement with global unions that they will do these things. The reason that those are not enforceable at the moment is because there is no mechanism to enforce them. This is exactly our problem, that we are overcoming the barrier of companies being willing to enter into legally binding agreements with us, but they need to know, how is it going to be enforced? Some of them are a little bit woolly and say, oh, the ILO will play a mediation role. The ILO, the International Labour Organization, part of the UN system, has made it clear that they do not want to play that role. So we are left without a mechanism to enforce the agreements that we already have, but we don't lack the will of the companies to enter into that, we think, because, companies have said to us, why would we worry about it being legally binding? Why would we enter into it? Because we intend to stick to this contract. The other interesting thing about working with multiple companies in the same sectors is that there is an interest of companies for us to hold their competitors to the same standards as them. And that is a very important incentive for companies to sign agreements with us because they want to know that we are holding the competitors accountable so that they're not being undercut on the policies that they have. And that is extremely good leverage for us. That is how we manage to get so many other companies into the Bangladesh Accord and be so comfortable with it being legally binding. If you talk to the more prominent brands in the Bangladesh Accord now, they will be calling for legally binding agreements with global unions. So we're at that point, but we don't yet have an effective mechanism for arbitrating on these agreements. So I do want to make this distinction that Marney's making between specific performance agreements where there is clarity around what those expectations are and what can be enforced, to the more general arbitration which is open up to all bodies on all issues. And I think it requires a different approach. Some of the mechanisms of the process may be similar, but the underlying contract that is the basis of those obligations is quite different. So we are a little bit worried that what we are doing doesn't get caught up into the whole, unanswered questions of the much broader field, that the little bit that we've carved out, which is what we have exercised through the Bangladesh Accord, is something that we can continue to work on because it's a very urgent need for us. And if there's cooperation that can be found around developing this mechanism, of course we'd be interested in that, but we do want to stick to our, specific actors, specific performance, specific outlined obligations in a contract to start with.
Thank you, Jenny. Bob, I think you had something to add. Is that right? Just quickly, I think we're running out of time, and we really do want Q&A for the audience. So, Bob, I'll leave it to you to have some final comments on that, and then I have one final question for the panel to contribute on, and we'll go ahead and turn it over to the audience. Go ahead.
This on now? Okay. Just a brief comment on this issue of getting companies to agree to use arbitration. In the business-to-business context, you have to be pointed out that when a business is trying to clean up its supply chain, it's first will look at its own activities and find out what's going on there, and it will also do due diligence as to what's happening in the supply chain and come up with a list of specific areas of concern. And in its contracts will likely specify the kinds of things that they want to mandate be cleaned up, and also some kind of compliance arrangement steps can be taken to clean that up. And those are specifically enforceable terms of the contract. It's interesting to note that the multinational is not imposing obligations on itself, it's imposing obligations on the suppliers. And if it has the leverage to require the suppliers to clean up their act and their suppliers and so forth down the line through what we call a perpetual clause, then its incentive is to clean up its supply chain, but it does not impose additional obligations or liabilities on itself necessarily out of one of these contracts. In the American Bar Association, we have a project involved drafting proposed contracts that contain perpetual clauses and dispute resolution clauses and so forth that will carry that out. Now, once these are in place, it will become what we call sort of a usage of trade, a lex mercatoria, to use the term, and that is sort of expected of companies. And that's where another kind of leverage comes into play, and that is where the investors, the BlackRocks, the major institutional investors insist that they have these kinds of contracts in place, or governments can say, and if you want a permit to do something, this is what you do. If you want to have permission to do something, this is what you want. You want to qualify to do business in our country, this is what you have to do. And that's the kind of leverage that can come out of the development of this I call the usage of trade. We have to get that usage of trade started, and that's why the lawyers who are involved in developing these contracts play an important role, and the lawyers who invite all their clients to use these contracts to clean up the supply chains play an important role.
Okay, thank you, Bob. We are very close to running out of time, so I'm just going to ask if we can turn it over to the audience and strongly suggest you ask a couple of questions, and including to address some of the questions you're going to talk about, including what the incentives might be for the businesses. We sort of touched upon it, but I think there probably is more discussion there. If we see more arbitrators becoming more involved in arbitration in business and human rights. See how I'm leading the Q&A. And now I'll stop. So we have a question here. I'm going to go ahead and turn it over there. Do you mind?
My name's Maria Diamante. I'm a PhD candidate. I'm writing my dissertation on the ILO. So any of you, if you would like to answer on the Bangladesh Accord, what was the involvement of the ILO?
Sure, I can answer that. Not much. I mean, nothing to do with the arbitration at all. I mean, the ILO doesn't want to go anywhere near actually arbitrating or even mediating between parties. The ILO, as you know, maybe others don't, is a tripartite structure made up of governments, employers and trade unions, and it's unique in the UN system in that regard. So anything that the ILO does has to be agreed by those three constituents. They played a very good role in helping get the accord going. They hosted the first sort of signing ceremony. They like doing that. And they provided a person to be a neutral chair of the steering committee of the accord. So the very, very neutral role, very hands-off, very much advice and support, but no more than that. So we know, as I mentioned before, that we can't count on the ILO for being able to provide the sorts of arbitration services that we require to enforce our agreements. It is not going to be possible for it, with its tripartite structure, to be able to accept to take on that role.
I know, because with the Declaration of Philadelphia 1944, they pivoted towards not just labor, but human rights. So to me, they've abdicated both roles, labor and human rights. Or am I wrong? Okay. Thank you.
I have a question relating to costs of arbitration and equality of resources that were two topics. And hopefully this isn't a sensitive question for anybody on the panel, but given the public interest nature and human rights nature of these disputes, to what extent could one expect to see plaintiffs represented by lawyers and law firms on a pro bono basis, and does it depend on the nature of the plaintiff?
With Covington and Burling, and we did represent the global unions on a pro bono basis for the Bangladesh Accord arbitration. I think certainly law firms with active pro bono practices could consider that, especially since the rules for arbitration don't necessarily have the same incentives for plaintiffs' counsel in cases where they're just seeking a large damages award, and so therefore, costs of counsel might somehow be covered in that way. So I certainly think law firms should be open-minded to providing pro bono services in this arbitration space, because particularly cases where there's a specific agreement and the remedy sought is not just a large monetary damages number, it may be difficult otherwise to incentivize plaintiffs' counsel to pursue some of these cases on behalf of victims or claimants.
We did a survey for the world's human rights organizations about 8 or 10 years ago. We asked that question in 16 different countries. What is the likelihood of pro bono services by lawyers? And what we discovered is a wide range of attitudes depending on the national firms. One of the biggest problems in I'll call it the third world is that the law firms generally don't use pro bono, don't do pro bono work. They are also fearful of alienating their business clients. That was the two observations that were made. So in the Western world, pro bono is used, particularly in the United States. It's a big issue and has been used pro bono for cases under the Alien Tort Statute, and it likely will continue. And we also found, we did a survey, Georgetown University did a PhD candidate did a survey of changing attitudes toward contingency fees and the use of pro bono. And apparently there's a sort of a rethinking going on, particularly in the global South, about loosening up on contingency fees and also more pro bonos being done, and also looking at the potential for, as I mentioned earlier, third-party funding of these kinds of suits.
Hi, I'm Malcolm Dornan from the Open Society Foundations. My question relates to the confidentiality of proceedings. What would your response be to the argument that the confidentiality of arbitration proceedings overrides what I would argue is a sort of overwhelming public interest to air and disclose proven facts and then help the development of robust corporate accountability case law? And not in the contractual sense with respect to the Bangladesh Accords, because I understand that there are competing relationship maintenance concerns at play, but in extra contractual concerns or harms. And I would also add that, you were asking about what incentivizes businesses to engage in arbitration. They love the confidentiality of the proceedings, so how do we balance that?
So, if I might, I think this is the crux of the challenge right now, and I think Bob could speak to it, that, for a lot of civil society groups, publicity is critical. I think for business to buy into this, confidentiality is critical, because the cost for business when we talk about these interrelated risks is not in the merits. It's not in coming to a conclusion. It's the public airing of the accusation and that being over the newspapers the whole time. And that's one of the reasons that arbitration would make sense over trying to go through the courts and fight it through the courts for business. So I think that it does make sense to develop some form of case law around core principles and develop more certainty on what is expected. But I think there has to be a way to balance that with the identity of the specific businesses at issue, because I think otherwise, because arbitration is consensual, a lot of that, the incentive to do it in the first place, dissipates the moment we have a presumption of publicity of all facts.
Just let Bob comment there, and then I'll take one more question. We are over 11, so thank you guys for staying over.
The issue of confidentiality, or the converse, transparency, was a major issue in all of our discussions. And there is an international trend towards opening up arbitration, even commercial arbitration. The IndustriALL has adopted 4 years ago, a set of rules about transparency, which ultimately are supposed to pertain to international investment disputes. In terms of whether business would agree to transparency, remember earlier I said that the multinational is not the one that's subjecting itself to liability, nor would it be subjecting itself necessarily to transparency. If it forced its supplier into an arbitration situation, the supplier may not have much of a choice. It must be open. And there's a major argument that it's in the public interest that human rights arbitration be open. I think it's a very compelling argument. The rules that are being developed have a wide open transparency provision. And whether or not the NGOs can actually twist the arm of the multinational that they're arbitrating, they're trying to have a problem with, remains to be seen. But they have a very, very good argument.
Okay, one more question. Anyone? Okay, great.
Hi, my name is Nancy Theven, and I work with USCIB. My question today, and thank you so much to all the speakers. This is a very interesting topic. We represent a lot of companies, so a lot of them are asking questions about this. What is the trend? Where is this going? Because we represent the ICC court, so we do a lot of arbitrations, business to business. So we understand the benefits and values there. We also have a corporate responsibility group, and they're trying to understand how the two separate groups, how can we work together to provide businesses with good guidance that we've heard from Yousuf here and all of you. Thank you so much. My question is about enforcement, right? So right now you have an agreement where the IndustriALL rules apply. So when I think about arbitration, I think of it as it's a mechanism, a procedure to enable the resolution of disputes. But at the end of it is an award that needs to be enforced in either courts. Is there, what is the thinking with respect to human rights violations that go into arbitration, and how would these awards, types of awards, get enforced? Because aren't you opening up another can of worms? Because they have to go to a state court. Is there anything being done to have some type of international mechanisms for enforcements or standards?
Just very quickly, at least the Bangladesh Accord makes clear the party's intention that the award should be considered a binding and final award under the New York Convention, and then could be enforced just like any other award. So to the extent that there is not compliance and there needs to be enforcement proceedings, the thought that it would proceed just like any other award under the New York Convention.
Yeah, in terms of whether that's a good idea and whether other options might be preferable, I mean, we're not there yet. Remember, the Bangladesh Accord settled, those cases settled. They didn't even reach arbitration. And that is always our goal. As I've said, we're not seeking punitive damages. We're seeking remedy. So that's why we emphasize the speed and the accessibility of the process. That's what arbitration should be. That's why we want arbitration rather than court cases, because ultimately we want the companies to comply. That's the whole goal of it. So if we've got to the point where, firstly, if they don't settle, if we've gone through every single dispute settling process, including conciliation, and we end up in arbitration and we haven't, and then even the arbitration award is not respected and we end up in the court, that is a very dire situation. As trade unions, we want a dispute settlement process that is quick and that gets settled at the lowest level possible. So that final arm of national level enforcement of a supposed international arbitration award is so far beyond, by that stage we're probably in very deep trouble if it's gone that far. So, but as a mechanism in itself, I don't think we're particularly worried about that, because we want to put in the more intervening steps that make it more possible that the settlement will come much earlier in the process. That's where we're focusing on.
Bob, is there a way, or forgive me if this is a sort of silly question, do the rules, the draft Hague Rules on arbitration, address this particular point in any of the preamble? And I don't think we've all seen this. I don't know when it's about to be officially published. Do you have an answer to this?
I don't quite understand your question.
On enforcement.
Well, the rules specifically say that the parties who adopt the rules agree that the arbitration will be a commercial arbitration within the meaning of the New York Convention, which means that it would be enforceable in roughly 154 states around the world. Just one more point. The rules also provide, as many arbitration rules do, that there's a relationship between binding arbitration and what leads up to binding arbitration. There's something called mediation is a step that normally people take before they go to arbitration. Before that, there's face-to-face negotiations and conciliation. What the rules provide is that if you reach a settlement in mediation, then you can have that become part of the award, so that having an arbitration clause enables you to make sure that your settlement agreement is binding in this vast universe under the New York Convention.
Okay, that sort of covers it, and we did go 10 minutes over. Thank you again for your patience and sticking around with us. I would encourage everyone here to reach out to anyone on the panel with any further questions. It's a very, very vast, critical topic that we're going to see grow over time and become hopefully more prominent and more codified and much more easy to navigate. So do feel free to ask questions of the panelists, and thank you for coming to attend. Marie-Claude, do you have any comments? Okay, that's it. And if anyone hasn't had any breakfast or coffee or anything, please feel free to grab that on your way out. Thank you.